So I'll just start recording. But good morning or good afternoon, depending on where you are. My name is Annika, and I am the Membership and Communications Coordinator at the Supercluster. And I'd like to welcome you all to our event today on the top 10 IP pitfalls for companies in the digital space. As the majority of our Supercluster team is based in Vancouver, British Columbia, we would like to acknowledge that we are gathered virtually on the traditional lands of the Musqueam, Squamish, and Tsleil-Waututh nations. Before we get started and I hand things over to Bill Tam to introduce our guest speakers, we ask that you please keep yourself on mute to avoid any feedback during the presentation. This session will also be recorded and distributed later today for you to refer back to and share with your teams. And finally, if you have any questions at any point during the presentation, please feel free to type into the chat box and we'll answer the questions as they come up. So with that, over to you, Bill.
Thanks very much, Annika, and good morning, good afternoon, everyone. Thanks for joining today. We have a very exciting workshop that we're very pleased to be co-hosting today. We have Brian Rafoul, who's one of the premier IP law firms in the country, who have joined us today. And I know many of our members are encountering sort of the opportunities and possibly some of the challenges as they think through their IP strategies. And so I think this workshop will be particularly helpful for you as you think through both your organization and in the context of some of the Supercluster projects and initiatives that you're involved in. So maybe where I could start is, let me just introduce the Brian Rafoul team and those that are going to be presenting today. It's my pleasure to welcome Natalie Rafoul, who who's an electrical engineer like myself, except she's chosen a better path to kind of pursue the IP arena and law. She is very, very well adorned with many awards as one of the top patent lawyers in Canada. She's been named to the top 40 under 40, Ottawa Businesswoman of the Year. There are many accolades for the work, the really, really tremendous work that she's done. She also happens to be a mother of three, and she's a board member and landlord, which I think the landlord part is particularly interesting, but we'll have her unpack how that relates to IP a little later on. Joining Natalie is Liz Gray. So Liz is one of the IP lawyers that works at Brian Rafoul. She amazingly has a background in astrophysics and computer science, which I think is especially important as we think about digital applications and maybe a little bit of space adventure that we're going to do here. But she has really kind of honed her craft around AI, machine learning, and some of the cutting edge technologies for which I think many of our projects and many of our members are involved in today. So I think it's going to be very pertinent for the conversations. She is an alto with the Cantata Singers in Ottawa, and I have a soft spot for that because my daughter is an opera singer. So she happens to be a mezzo-soprano. So I think it's fantastic that people have other things other than talking about IP all the time. They have other things that occupy their daily lives. And finally, let me welcome Dennis Hasko. So Dennis is a senior patent counsel with Brian Rafoul, and he's worked in Canada and the US for over 3 decades. He's worked with some of the big firms like Nortel and a number of sort of US firms along the way. I think he is kind of contributing his time and his know-how towards this conversation with more than 3 decades in the business. So with that, maybe I can turn it over to you, Natalie, to share the insights about the top 10 things that people should be aware of. Natalie, I think you're just on mute there.
Sorry, I'm just trying to share my my screen. Why is it not? Got some kind of, there we go, perfect. Okay, so can you see, do you see just the screen right now? No, or no? Okay, wait a minute, I'm sharing just a second here. Screen 2. Okay, is that working now? Do you see the, okay,
That's
great, perfect. Sorry about that. All right, so thank you so much to Bill for that really great introduction, and really to Cream and others at the Digital Supercluster for inviting us to do this. We love giving talks about intellectual property and love working with early stage innovation companies. We work with companies of all size, but we love working with companies who are really sort of at earlier stages trying to develop their IP strategy. And over the decades now working in this space, I used to come out and give talks and just talk about, what's a patent, what's a trademark, and just work through the different forms of IP. And I think, nowadays really focusing on what are we seeing out there? What are the big pitfalls, and focus on that. And so I'm really excited to be joined here by my colleagues, and Dennis being a former mentor and former boss of mine too. So it's great to have him with us today, and a former U.S. Patent Office examiner too. So let's get into it. Just before we get going, we are gonna talk about the law, intellectual property law, legal principles. We are lawyers, we are patent agents, but we are not your engaged professional. And so of course, nothing here constitutes legal advice for you. And if you do want some specific advice, of course, reach out. We're always happy to talk, and always happy to talk initially as a courtesy as well. So if you have questions after this and you want to talk about your specific company situation, we are happy to answer questions. So really, as we get into it, there's kind of 3 high points. It's always important to sort of review what is IP, what are we talking about when we say intellectual property, and then of course really focus on what's important for digital companies in the digital space. What are the issues there, and then get into the top 10 pitfalls that we see. So again, just coming back to first principles, intellectual property is really an umbrella term, and it's an umbrella term for creations of the mind. So we think of ideas, inventions, designs, anything intangible, symbols, names, images. So it's really all of these sort of things that are created, are creations of the mind. And next to that is intellectual property law. And what intellectual property law does is it carves out rights, certain exclusive rights for owners. Sorry, I'm just gonna try to, I'm gonna try to move. You're in the middle of my notes, so I'm gonna just take a minute here to move you so I don't see you in the middle of my notes here. Sorry about that. And I'm not able to do that right now. How do I minimize you? Perfect, okay. Now I can't see you anymore. So intellectual property law is really, what intellectual property rights do is they carve out certain exclusive rights for the owner of that intellectual property asset. And so it's important to think of that exclusive right concept, because intellectual property rights don't necessarily give you the right to do anything. It's more about giving you a right to exclude others from having access to your intellectual property, your intangible asset. It enables you to keep others from practicing or making or copying your intellectual property, your creation. So we can't get into all the different forms of intellectual property, but it's good to sort of cover at a high level the ones that are most common, that come up the most. And starting with, at the creation stage, all the way to things that are more in the public domain when we think of brands and what is out there more publicly. So starting with copyright, what is copyright? So copyright protects, it's a form of protection that is available in most jurisdictions globally. And it protects things, as I said, as literary, artistic, dramatic, or musical works. It also protects source code. So this is where it comes in and is important in the digital space. But it doesn't offer, it's important to note within the software space, it's not going to offer the kind of protection that is very strong. And we'll kind of get to, I'll speak a little bit about this recent decision that just came out with Oracle. But there is some protection for your source code, so that the way you actually coded something. And copyright, your copyright exists as soon as you create that work. So as soon as you start drafting a technical specification, or you start writing marketing materials for a customer, or you begin drafting out, creating that code, you have copyright in that code as soon as that work is created. There's no requirement for you to then put that out in the public domain. And as soon as you created that original work, you are able to prevent others from copying that. So, and in terms of the length of time that copyright protection lasts, it lasts from the life of the person that created that, or the life of those that created it together. So if they're a group of authors or a group of coders in the digital space, it would be the after the last person, the death, the last coder, going from, let's say, 25 to 75 years. It depends on the jurisdiction, but depending on the country, there are laws now in the books that last from 75 years after the death of that particular coder. Moving on to trade secrets. Trade secrets is a form of protection that differs from country to country. Some countries actually have trade secret laws on the books. Others, for example, in Canada, it's really governed by common law. And it really, but notionally, it's all the same in terms of the protection it offers. So trade secrets are really valuable business information where the value is really derived from maintaining it as secret. So things like sales methods, client lists. One of the most famous trade secrets is, of course, the formula for Coca-Cola that has been kept secret all this time. Suppliers lists, algorithms that are sitting in that black box that are, you've not shared outside the company, a very limited set maybe within your company have access to those. The key, though, is to really not only have trade secrets that are in control of the company, but have processes around that maintain it as secret. So in order to prove later, for example, that there was a trade secret theft, you actually have to show that you've taken steps to protect that trade secret. So what's very important here is keeping things, having strong confidentiality agreements, having strong employment agreements, making sure that those that have access to that trade secret information are the ones that should have access to that. And what we find a lot of times is a lot of companies, especially in the digital space, are employing a strategy of copyright, trade secret, and the open source, and there's no trade secret policy on the books. And that's really important to really think through who should have access, how are you protecting things, are you encrypting things, and make sure that there's some policy on the books. Because later when there is a trade secret theft, and we're actually seeing some issues even with some Canadian companies in the news lately, that you want to make sure that you can show you've taken steps to protect things. And then moving again to things at the creation stage. So ideas, how do you protect ideas? Of course, copyright, when we think in the software context, it will protect the source code, but the ideas behind that source code, the methodology that is coming to life in that source code, that methodology can be protected through a patent. And patents protect things that are new and not obvious in light of what's been done before. And so to make that clear, you can't go to some remote part in Russia and find someone that's implemented or discovered some new algorithm and then come to Canada or the US and patent it here. So it has to be new as against what's been done in the world that's in the public domain. So anything that's been published globally would constitute prior art and would render it not new. But when you do get a patent, what it's going to enable you to do, and coming back to this concept of excluding or exclusionary rights, it's going to enable you to prevent others from selling, making, importing into the country where you have protection. And of course, patents can cover products, processes, system architecture. And once you file the patent application in a particular jurisdiction, that protection can last for 20 years. Moving on to designs, which is a lesser known form of protection, and we'll look at it quickly through an example, but industrial designs protect the features of shape and ornamentation of a particular product. And again, with design protection, when you have a registered industrial design, or they're known in the US as a design patent, it's going to prevent others from copying that particular design. And for graphical user interfaces, design protection can be a fantastic form of protection, for example. And that protection in some jurisdictions can last up to 25 years, so even longer than patent protection. Google has a very famous GUI that is coming off the book soon, but it is still, their landing page, that very iconic Google landing page, is still the form of a design patent that is still protected even 15 years down the road now. And then trademarks, you're probably familiar with trademarks, pick up if you've got any soft drinks on your desk, or you've got any products with trademarks on them. Trademarks protect those brands, but they also protect logos and slogans and can be a very important and valuable feature of your business. Conversely, the trademarks of other competitors in your business can be something to really be mindful of, because that type of protection can, if they've got a brand that is similar to yours and are finding that your brand is causing confusion with theirs, you may have issues downstream in terms of making sure you can sell your product in the marketplace. Trademark protection can last in perpetuity. And what happens when you do register for a trademark, you have rights, you are able to maintain that in perpetuity provided that you renew it every 10 years. So there's lots of famous brands that are registered trademarks and have been for years. Example, Coca-Cola again. So just breaking it down, looking at a software example and taking a look at Instagram, for example, which is owned by Facebook, as many of you probably know. Of course, they're going to have protection. They're going to have copyright protection in their source code. One thing to note, though, is that the headlines that maybe you saw the Oracle U.S. Supreme Court decision. It was the Oracle versus Google case. And there is concern now that this decision may have weakened copyright protection. I know we were talking amongst ourselves within the firm that the decision in favor of Google, which had copied about 11,000 lines of code out of millions of lines of code, but it was for an API, in particular for an API situation. This might have, this decision by the U.S. Supreme Court to say that the copying by Google was a fair use of Oracle's code in the Android context. You can read about the case. I'm not going to delve into it. May have sort of weakened this form of protection. And so just be mindful that copyright, really, if you're relying on copyright protection for your code, it's not the greatest form of protection. And if you're trying to protect functional components, as I mentioned here under patents, patents are really going to be patents or trade secrets are going to be a very important form of protection. And in fact, the decision, many commentators on the Oracle Google decision mentioned that, look, it might motivate more and more companies to think about trade secrets and patents versus copyright protection in the software context. And then of course, Instagram, Facebook will have certain algorithms sitting in black boxes that are maintained as trade secrets, other things that they have on customers. This image on this slide is one taken from a Facebook patent that could easily be used for the Instagram application. But looking at sort of methodologies that may be patentable and going after patents on various methodologies, system architecture that they can protect. The Instagram user interface is actually very iconic, and it has a certain look and feel and shape. And of course, here we're showing how when you go to like an image on Instagram, you get that icon, that heart icon showing up. And then with trademarks, of course, they have the Instagram trademark, but they have a lot of great brand images, logos that they protect as well. So why does IP matter? And just wanted to kind of get into that a little bit. And really it matters because the world has changed over the last 50 years, and intellectual property and intangible assets, which are IP and data, are really the primary drivers of wealth and success in the marketplace. And if you look at companies such as Apple, Amazon, Google, Facebook, Microsoft, and you look at their combined value, which is in the $7 or $8 trillion value at this point, they, only 4% of the value of those companies is residing on average in their tangible assets. The majority of the value in these companies is really residing in the intangible assets. So really the IP, the data, the contracts, the goodwill, the brands, all of that, the trade secrets, that's really where the value resides. And when you think about company value, the majority of the value really residing in your intangible assets, how much emphasis are you putting on this strategically? And if we look at Canada in terms of how we manage IP and data, what we're seeing is, for example, in the AI context, that sure, we are innovating in these spaces, but we are not the owners of those innovations. And in fact, a somber statistic, but it still plays out today, is about 70% of the roughly 1,600 AI and ML patents filed by Canadians are actually owned by foreign companies. And so a lot of what we're inventing here is not in our Canadian hands. And so it's something to be mindful of. There's this trend of, sure, we may be coming up with really great ideas in the digital space, in the digital context, but these software patents are owned by someone other than Canadian entities. And so if you want to see who owns it, no surprise, this is a little bit old 2018 statistic, but of course the US being a dominant player in holding patent assets. China is growing, and in fact, China's bubble there would be much larger. And Japan too, very strong lead. This is taken out of the USPTO, the US Patent and Trademark Office just issued a report on inventing AI. And it was interesting to note that there's been a 100% increase, for example, in the AI ML space in terms of patent filings. 30,000 to more than 60,000 patent applications being filed annually. So massive growth in that area. And what's surprising to some is to see the number of patents in AI that are now granted patents. So we're not talking about applications, but actually granted enforceable rights, with IBM having a runaway lead in the AI space, and Microsoft coming in second there, and then Google as well. And if you look down, Amazon with over 5,000 patents in AI already. And then and I like to take a deep dive, there's been a lot of studies recently on AI. And so, if we're talking about the digital space, I know not everyone's going to be working in AI, but, this is, when we talk about statistics around AI, this could be playing out in other contexts as well in the digital space as well. We are seeing a real domination, for example, in patent accumulation by large multinational entities. And so when we look at AI, most of the top 30 applicants are conglomerates that are active in consumer electronics, telecom, and software space. 12 of the top 20 companies, surprisingly, are Japanese. And we're seeing a continued buying spree. So for example, 7 of the top 20 companies acquired AI-focused companies. And Chinese research institutes, playing a very dominant role. So it's interesting to see how the big companies are performing in the space, and really the aggregation of patents. And yet for SMEs, and Canada is really a country of small, medium-sized entities, this is really important for us to get in the game and to really be looking at IP assets as helping us, as having strong correlations to really driving revenues. So for example, this was taken from a European Union EPO, European Patent Office study that just came out a few months ago, saying, look, SMEs that have at least one registered IP right, so we're talking about registering a trademark or registering a patent, earn 55% more revenue per employee than SMEs with no registered IP. SMEs that own both patents and registered trademarks, so at least one of each, generate 75% more revenue and grow faster than SMEs with no registered IP rights. Now, some may say, okay, well, these studies don't show causation, but they show a strong correlation. And I think what they're telling us is that companies that are mindful about their intellectual property and their intellectual property rights and have a strong strategy are just strong sort of in all domains. And it forces them to think about, what do we do that's different, right? It forces you to do a bit of a SWOT: strengths, weaknesses, opportunities, threats. So what are you strong at? What's your big market differentiator? What are your competitors doing? So really being mindful, what's your competitor patenting? What does your competitor's brand look like? What's their strategy? So making sure that you're being mindful of what's happening in the marketplace. And, big players are strategic. So just kind of, highlighting these antitrust reports is that, as SMEs, you're going to partner with larger players. Remember that these players are sophisticated. Apple, Amazon, Google, Facebook, increasingly serve as gatekeepers of commerce and communications in the digital age. And then you probably most recently, maybe you've seen the Wall Street Journal article, Amazon met with startups about investing and then launched competing products. So of course, we see companies are naive. They get into discussions without clearly delineating, whether the conversation is around something proprietary that the bigger player is not going to have access to without getting a license. Maybe that smaller company did not file a patent application before divulging that information to a big company like Amazon or Microsoft. And so we see these situations repeated where companies have just been naive in those conversations. And unfortunately, with most recently, this just came out this month, is Ecobee, one of Canada's darling SMEs in the smart thermostat space, has just come out now and said, look, Amazon has been leveraging its dominance through a variety of agreements, basically to pressure Ecobee into sharing user data. And this has been very challenging for Ecobee because they don't want to be sharing customer data, because to them, in their perspective, this was in the Wall Street Journal article, this is the breach of trust with their customers. And so, but Amazon, through its web of companies and the way they structure these agreements, really has had Ecobee in a very difficult situation. And Ecobee's still hoping to work with Amazon because, of course, as I said before, these companies are dominant players, and you have to be able to work with them if you want to operate in the global marketplace. So let's get into the pitfalls, and now that I've set the stage on why this matters, what are the things that you really need to be thinking about? And so first and foremost, we see companies really lack an IP strategy. So they may be doing some things, but overall there isn't really a strategy around, how best to protect themselves, how best to create value for their company by using intellectual property strategies. And so there's not a focus there. Neglecting software patents. So it was interesting. I was listening to litigation counsel for Shopify a couple of weeks ago, and he was saying, look, I mean, patents might not be important for you as a company as part of your strategy, but don't forget, for your competitor, that might be part of their business strategy. And so being mindful that you may not be patenting, but your competitor might be patenting. And so what's going to be your strategy around that? And then public disclosure. Big issue, because once you put things out in the public domain, you can't put the genie back in the bottle. You can't patent things that are already out there. As well, freedom to operate. So making sure that you have global freedom to operate. So not just being able to move freely in Canada, but are there patents or are there trademarks blocking you in the US, in Europe, like where you want to move, do you have freedom to operate? And then maybe you've gone to the trouble to patent or protect things early on, but you're forgetting about your improvements. As you're continually improving your product, what's your process around that from an IP strategy point of view? And then not thinking about the brand. Sure, you have a brand, but are you mindful of how you're protecting that, that through trademark registration, through your domain name? We will get into that as well, but thinking along the lines of how to best protect your brand. And then the misuse of open source, not really understanding those licenses that you're signing on to, not understanding what you're incorporating into your own product, unclear ownership situations. So you get into joint ventures, or you have, you've got contractors working for you and you think that you as a company own that intellectual property, perhaps you don't. And over-reliance on template agreements and no long-term planning. So on that note, I'm going to pass this over to Dennis to take over from here.
Thank you, Natalie. I'll try to request control here. And got it. Okay, I should have control now. So, pitfall number one, lack of IP strategy. In determining an IP strategy, you obviously need to take into account your business goals. Without the business, there is no point in patents or IP in general. So international markets are something that comes into play here. Keeping in mind that patents, especially when we're talking about patents, they're the right to prevent others from making, using, or selling your invention. So you have to look at the markets where you're actually making, fabricating, manufacturing the product, or where the market is using that product or selling that product. Those may be very distinct markets. So keep that in mind, that the international markets may dictate where your strategy follows. The competitor, likewise, the competitors' IP portfolios, that's important. If you have a primary competitor that perhaps is a software developer in Germany, for example, you may want to focus a little bit of your patent efforts, your IP efforts in Germany itself for strategic reasons. Timing and funding are aspects that you might consider in your business goals. Timing dictates how you utilize a strategy. For example, if you want to address funding with some venture capitalists, you definitely want to get something on file with a given patent office as quickly as possible. For example, in the U.S. Patent Office, you may utilize the provisional patent application process in order to get an early application on file, so that your timing dictates your strategy there as well. Commercialization and licensing opportunities, depending upon your particular the life cycle of your development. Commercialization may be something that dictates when you pursue a particular avenue of filing your patent applications. As well, licensing opportunities are interesting. One thing to keep in mind, not only a granted patent obviously is going to be something that you could license, but also a pending patent application is something that could be licensed. So there again, your business goals dictate your strategy about when you seek to license your IP and what form that may be in at the time. Okay, there's a lag, so I don't want to get too far ahead. Of course, it's not working. There we go. Okay, so with the timeline in mind, as far as your business strategy, what does the timeline of when you file, where you file matter, and how does the system in general affect your use of patent system? Under the Paris Convention global agreement, after your initial engagement, your initial filing of a patent application, and in this timeline example, it would be at time 0, you initially file a Canadian patent application. Under the Paris Convention, you have 12 months to file in any given foreign jurisdiction that adheres to Paris Convention. That would be most countries in the world. So 12 months is not a very long time, but that does afford you some benefit to avoid having to make the decision immediately to file in multiple jurisdictions all of a sudden. So the 12-month mark is something to keep in mind, but as an overlay, and I'll try to fast forward here again. There we go. As an overlay on the patent system, there is another method that exists, the Patent Cooperation Treaty, or PCT for short, is a mechanism that's in place. There are 140 some odd countries that abide by the PCT, the Patent Cooperation Treaty, and that's an extension of that 12 months in some regard. So in this timeline, you see that you have either a US or Canadian initial filing at the far left of the timeline. And what the PCT affords you are multiple levels here. It affords you the opportunity to file one corresponding application at the 12-month mark, the 1-year mark. And that application follows its own process, and it affords you up to 30 months to make your decision about foreign filings. Now, that seems like a lot, but 30 months can be eaten up very quickly when you're doing all of your business development behind the scenes. But what that does do is give you more time to make your better informed business decisions about where to file, be it Japan, Europe, or other places, and other issues that come into play here. I mentioned VC money, finding funding. The PCT process actually affords you, between that 12 and 30-month mark, there's a time period where you actually get a search report and an opinion out of the system, the patent examination system under the PCT. You get a search report and opinion, and that can be very valuable, because if you get an opinion that your patent claims, basically your invention looks and smells like it's going to get a patent and be a smooth sailing through the patent office, so to speak, that is valuable information that you can gain early on for convincing some financial backers whether to throw money at you and actually support you in your decisions. And that can help you fund the ultimate costs that are related to the filings that are on the right hand of that timeline, further filings in Japan, Europe, and other places. So continuing with pitfall 1, lack of strategy. One of the things a couple of things that's important here, developing, no matter if you're a small company with just a handful of people or a larger startup with a whole team, a whole crew of people, some internal program is quite an important step to formalize in as much as you can something that addresses early on any IP issues that come up, and developing those procedures is key to think about and customize those for your business goals. So setting up that IP program, though, effectively, what does that do for you? It can do quite a few things as far as helping you to become more IP aware within your culture, within your company. Obviously, doing that may have some consequence of increasing the amount of innovations that you tend to see day to day, or at least innovations that you can more easily visualize that they exist as innovations. Because one of the problems, though, is that this is your everyday job, and coding or developing the software and how it interacts with the networks. That's something that it's a sixth sense to you. However, where that light bulb, that aha moment goes off may not be a sixth sense. So developing that program, that IP awareness is a great thing that can help you become eventually more proactive and less reacting to the situation. The last thing you want to do is wind up calling a patent attorney after you've gone down the path of disclosing this to others and so on and so forth. So keeping that awareness going in an IP program is very important to set up. And in terms of the details of an IP program, it's important to realize that we're not just talking about patents. We're talking about all of the full spectrum, like the Instagram slide that Natalie put up, the full spectrum of possible ways to protect your IP. They're all just business tools. Whether they're the right tool for you is something that you need to conduct some analysis and include a good professional, IP professional to guide you through that. But considering all forms of IP is important. And getting buy-in basically from all parts of your team. Obviously, there may be a champion among you, among your team, that knows about the importance of IP and protecting IP, commoditizing IP. However, that doesn't always trickle down to rank and file coders, rank and file R&D that may consider, like I alluded to earlier, may consider what they do as just their sixth sense. This is something that's an obvious improvement. But one thing to always keep in mind, that obvious is an interesting term. Obviousness is not a layperson's perspective. Obviousness, as far as a litmus test for patentability in the patent world, is a very distinct way of thinking about the technology that's come before, and whether, based upon all of the information in front of you, whether it is obvious to do. So it's not an off-the-cuff analysis, but IP education sessions, things like that, help make everybody more aware throughout your team. So oftentimes product evolution, the prototype is not something that's the the finished product is not something that wows people. At some point, there's some aesthetics, some thought put into aesthetics, into the market, to the end user, to make the interface of the software more user-friendly, to make a particular electronic smart device more aesthetically pleasing for the end user. Those are extremely important details that shouldn't be lost in the concept here, because design patents are quite important. Years ago, I had done work for a company, Delorme Mapping, old school company related to producing just that, maps. But they morphed into another facet of their business with GPS devices, and at the time, software was based on CDs, and just the packaging software of the display packaging, that was fodder for design patents, and very useful for that particular client. Apple is an interesting beast because they have used not just utility patents, which cover the functionality of invention, but they've used design patents for everything they do. The look and feel of an Apple product is quite distinct. So much distinction there that they actually broke ground with three-dimensional trademarks as well. So that's another interesting concept, that trademarks can be used for three-dimensional objects. Continuing on that theme of Apple's designs, they've done a very good job with their interfaces. One thing to keep in mind are like icons. I think Apple issued just recently obtained another design trademark, a trademark for an icon related to COVID, for a COVID app. And but one thing to keep in mind, that design patents can cover icons as well. And one of the interesting facets of design patents are animated designs. So that what's a good example is booting up your Android phone. They've recently changed the little swirly thing that goes around with the bright colors and things like that. But those animated icons are something that is very distinctive and easily protected through various tools, one of which is a design patent for an animated icon. I may have clicked too many times, but we're good at the moment. Continuing again with the Apple theme. Apple, back in 2010, I think the Galaxy S was, Samsung Galaxy S was launched, and there was a suit. Apple asserted its patent portfolio, its design and utility patent portfolio against Samsung for not just the functionality of things that were occurring in the Samsung product, but the look and feel, the aesthetics were very similar. The point being here, Apple did a very good job at protecting, patenting the heck out of their product, and I've hit forward, but I am not going forward. There we go. So one of the interesting byproducts here, design patents, from quite a few people's perspective, design patents are sort of the ugly stepchild of patents, and maybe not as useful because what you see is what you get, and they can be oftentimes easily overcome by changing just a subtle nuance to your design. But here in the Apple Samsung case, you can see the order of magnitude of the value of design patents for Apple. So it's something that that you should not overlook. And as Natalie mentioned, it's industrial designs in Canada and design patents in the States, but effectively it's the same mechanism that protects you for the aesthetics, the look and feel of your particular invention. So in setting up that IP program, there's things that you need to keep in mind about the how. How do you do this? Internal disclosure is something that's something that you should keep in mind about amongst your team, letting information outside of that circle. In kind, document management is key as well. Those types of systems that you may have in place about document retention, document versioning, things like that, just to keep a paper trail and maintain control of that information. Product branding and clearance, those are types of things that that will be key in an IP program early stage, as far as the branding may end up getting ahead of themselves in terms of marketing. So disclosing information before you've gotten your head around how to protect is something to keep in mind in your IP program. Third-party involvement. What comes to mind is my years at Nortel in-house there. We did a lot of work in my particular group with McGill. So there was joint development with McGill professors and sometimes extracting the IP and making sure that it was always owned in the company's name. So so that's very important to establish around your IP program, how your IP strategy is affected by third-party involvement. Onboarding and exits. This can be extremely key with startups where it's somewhat fluid about people joining and people going. Case in point, I've done work for not a software related, but most folks know shaving equipment. Gillette is a big company, and a team of their researchers left Gillette and established Shave Logic. It's a company out of Boston, and doing some really nifty things with magnetic heads for replaceable shaving equipment, like hair on your face type thing. And but they struggled because they left with purportedly information related to IP and started a company that was a direct competitor. So exits from staff, key staff, or even just rank and file staff is something to get your head around as far as how you're handling your IP, ensuring that your employment agreements are up to snuff, and people aren't walking out the door with your IP. Oops. Security considerations in your program, your IP program. So IT is an obvious thing as far as the access to your information. You need to safeguard it and take all necessary protocols into mind when you set up your program. Trade secrets, as Natalie mentioned, is extremely strict in terms of if you think you have something that it's not worth patenting, it's something that's sort of your know-how, but it's something that's in your black box, so to speak. You need to maintain that in your black box. So all the procedures need to be in place for actually safeguarding that information, whether it's on your servers or in your filing cabinets, precluding people from having a limited amount of people that have access to information and adhering to all the other ground rules that are key to establishing and maintaining a trade secret. Confidentiality agreements and non-disclosure agreements, NDAs, effectively one and the same. Those are something that they should keep in mind. I'll discuss that in a little more detail in a bit. But, and third-party data, it's not only providing third-party data to third parties, but receiving third-party data. Those are things you need to keep in mind, that you are the gatekeeper for potentially confidential information from a third party. So those procedures that you treat as confidential for your own matters, you should also be aware that you're not stepping on any agreements that you may have in place with your third party providers. Neglecting software patents, pitfall number 2. As far as software is concerned, what has historically come to mind is copyright. And there's this yin yang between the open source world and the folks that are leaning towards protecting everything. In having that mindset, you have to ensure that you're not discounting the value in any of those improvements that you've made in your computer implemented inventions, your business methods that relate to how your software interacts with the network elements or the end user. Those things can be extremely powerful aspects of your product that can be protected. So by all means, always consider the possibility that your software, of course, yes, it inherently has some copyright in it, inherently by the fact that it comes into being under common law, but you also should consider that the manner of using your software, how it interacts with the system elements that are involved with your product, those aspects may be great fodder for a business method patent or a computer software related patent, computer implemented invention. So why would you bother? There's the open source stream of consciousness, but there's also the protected stream of thinking. So why would you protect things? There's the obvious. It's a hammer. It can be an offensive tool for you, and that's important when you're in a field where it may be a highly competitive field, and there's lots of solutions out in the marketplace, but you've come up with an interesting, intriguing twist that is an improvement upon all that is out there. So you may want to plant your flag in the ground and use it as an offensive reason for purposes of looking for targets. The other reason to cover your IP with some protection, be it whatever, patents or copyright trademarks, would be for defensive reasons. So cross-licensing is something that people don't think of immediately as a possible benefit. The value to a patent is not just I'm getting echo from somebody, not unmuted. So the value to a defensive to a patent may be if you were to be approached by another person in your space, another entity in your space with a cease and desist letter demanding royalties. If all you have is your raw idea, then all you have is your checkbook to pay royalties. However, if you have some semblance of a patent portfolio, even if there's pending applications, you have the potential for cross-licensing and diminishing the amount of you have to actually write out in a check if that's what the outcome will be. But cross-licensing affords you the opportunity to basically barter in a defensive manner with your IP assets. And like I mentioned earlier, funding is key, and having something to go to your financial backers with, be it a pending patent application or a patent granted in hand, or is one thing, but if in the scenario, I always have to consider the worst case scenario as well, and what you have left at the end of the day. Oftentimes at the end of the day, what you have left is your patent portfolio that commoditizes your IP, and that is something that can be valuable and can outlive your company. Or in other instances, actually both Natalie and I had worked many moons ago for a company, Mossade, here in Ottawa, and early on they were a semiconductor business that created memory devices, and at some point down the road they realized that it was more lucrative to not make the widgets, but actually just make the IP, make the intellectual property. And they morphed into what is called a non-practicing entity, or by less loving terms, a patent troll. But in any case, they turned into a company that had a robust licensing program and actually ran a business off of that concept of licensing, keeping their business alive, but in a different form. So that's something to keep in mind. Another case in point, leveling the playing field. Patents are an incredibly powerful tool, presumed valid from the day that they're granted. They're presumed valid, so they're something they're a tool that's somewhat self-policing in some regard. Patent is out there, and it puts people, by its mere being, puts people on notice that you have the rights to it. So an example here is I4I. In the late 90s, they had obtained a patent on improved method of XML, using XML markup language for document editing. They approached actually Microsoft, but as things played out, Microsoft was not interested at the time. However, strangely, oddly enough, they began using a similar concept to the patented I4I's patented approach, and in their Word products, and that may or may not have been the facts as laid out, but I4I managed to prove in court that Microsoft actually willfully infringed that patent, and they walked away with a very generous award of $400 million US. And not just that, but also put Microsoft, so to speak, in a box regarding the sales of any software product that pertained to that patented method. So asserting their patent, they wound up coming out quite ahead with money in the bank, and also a better landscape in their where they were working. Pitfall number.
You have to speed up a bit.
Sure.
Time, yeah.
Pitfall number 3, public disclosure. That's something where it's important to keep in mind that if you do actually disclose your concept in any public way, or you may rule out, actually preclude yourself from obtaining patent coverage. The US and Canada have a grace period of 1 year in order to pursue a patent, but other countries have what's called absolute novelty, and that's a cautionary tale. Disclosure again. So where can these things happen? Discussing with investors, any of the marketing material you let out the door, discussing with friends, friends tell friends. One thing to keep in mind that anything that you work under a non-disclosure agreement, something like that, but in as much as possible, but that's just a contract that is as good as the paper it's written on. So unless until you have a patent on file, patent application on file, you don't really have anything to rely upon. So public disclosure is important. In the US, there's this other odd facet that if your invention is ready for prime time, in other words, you dream it up in your mind, but if you explain to somebody, they can actually put it together and it can come into being. If it's reached that stage, it's ready for patenting. It's therefore reduced to practice. If you offer it for sale to somebody without even actually including the details of what you're making, that offer for sale and plus the fact that it's reduced to practice equates to a public disclosure. So that's a cautionary tale. There's no such thing as a secret sale or a sale under an NDA in the US. That can start that grace period running for you. And like I said, non-disclosure agreements, NDAs, those are only, you've got to be aware that it's a contract. You've got to deal with all the details and requirements of contract language, the parties, the coverage, enforcement, and breach of that contract can occur. And that's still disclosure. So it's only as good as the paper it's written on. It's only as good as the parties that adhere to the rules of that contract, that NDA that you make with them. Pitfall number 4, freedom to operate. So here it's useful to keep in mind that that you're 9 times out of 10 you're an improvement upon the technology that's come before. So whether or not you are free to do that, to practice that inventive extra step is something that's very distinct from the inventiveness or the patentability of that particular piece of technology. So, for example, the technology that you're doing may involve, in a simplified version of the concept, elements A, B, and C, yours being an improvement C. But if somebody has a patent on A and B, then you have incorporated a patented technology into your product. And so beware of other people's rights that may cover what you're improving. And pitfall number 5, continuing on the concept of improvements, is neglecting improvements. 9 times out of 10, or 99% of the time, all patents relate to improvements. Just probably less than 1% of all patents are those leapfrogged, earth-shattering technology differences from what's come before. Most of the time, our job is to distinguish between the improvement and the prior invention, prior art that exists before. And that's baby step improvements. And it may not be readily apparent to people that are working rank and file, working daily on those improvements, but improvements are key here, and you really should be thinking about every little improvement as a possible patentable baby step. For example, Thomas Edison, I mean, there's a good analogy to be made here. Thomas Edison may not have been the brightest bulb in the world, pardon the pun, but He was a shrewd businessman. There's a good analogy to be made to Elon Musk, and I won't go any further about the dim bulb concept there, but you know, running with the ball, you don't need to be the rocket scientist to properly utilize the patent system to your advantage, and not necessarily even the first. On the note of improvements, and going back to the timeline, improvements, where do they stand in the timeline? The US has what's known as a continuation in part, or CIP, method of tacking on new information. So in this timeline between the 12-month mark and the 30-month mark, that's a situation where your R&D is continuing. You're getting feedback on your prototypes and so on and so forth. So you may come up with another aha moment where you're doing things slightly differently, and it's distinctive, it's different, it's an improvement upon your improvement. Where does that lie in the timeline and in the strategy? Improvements can be recaptured and put back into the timeline through continuation applications, and here a CIP might fit into the timeline in that place. Pitfall number 6, neglecting your brand. Trademarks are the...
I think Dennis, Liz is going to jump in here now.
Sure, okay.
Yeah.
Thank you.
Liz, you're muted.
There we go. Hi, everyone. So pitfall number 6, neglecting your brand. So trademark strategy, as continuing this theme of strategy, having a strategy from the beginning is really critical. Using your trademarks cleverly to distinguish your goods and services from your competitors is really central to helping people find you and knowing who they're dealing with. There we go. So you can have a registered trademark as well as an unregistered trademark. An unregistered trademark comes into being when you start using something as a trademark, when you're using it to refer to your goods and services. Not every country has those, but the US, Canada, the UK, a few other jurisdictions around the world provide unregistered trademark rights. So you might think, well, if I have that protection, why do I need to register a trademark specifically? Why do I need to pay extra for that? Well, registering a trademark actually provides significant advantages over just relying on your unregistered rights. It's different from doing a clearance search for your business name or just Googling and making sure that you're not running into anything right when you're doing your branding process. Registration generally in Canada, for instance, it provides you countrywide protection regardless of maybe you just have one small store or you're only really known in one space. And this has come up a few times in some interesting ways. One is Target apparel. In about 2005, the retailer Isaac Benetton registered Target apparel as a Canadian trademark. And this was before Target, the US department store, was active in Canada or had physical stores here. And so when Target did try to move into Canada, it found that there was this registered trademark blocking it. And he was in fact using Target apparel, as you see in this slide, for a couple stores. There was one in Toronto, one in Sudbury. So it was a live, active trademark. And it became quite a problem for Target Corporation, actually, because they wanted to use Target in association with clothing, among other goods and services that they sell. And they were finding that they weren't able to. And it became a very involved litigation process. They eventually settled with him, and the amount of that settlement is estimated to be in the millions. So that's the sort of default protection that registration can get you. And it suggests that if you're planning or considering expanding, and definitely in the digital space where you're probably active in the US, you might be active in Canada, maybe wherever the App Store is available. It's really important to figure out where you want to sell, where it benefits you to sell, and what sort of brand protection you need in the markets where it's really valuable to you. So how do you choose a trademark itself? Trademarks are about identifying the source of goods, not the goods and services themselves. So the more distinctive and less descriptive your trademark can be, the stronger it will be. The absolute strongest marks are the ones that aren't even words. They're coined words, they're unique, like Exxon, like Xerox, Kodak, Lululemon, the words that have no meaning in any language, you just made them up. Strong marks are words, but they're not related to the goods and services you're selling. So Apple for electronics, Puma for clothing and sports equipment. You wouldn't think of sports apparel if you saw an actual Puma cat. Then you have weaker marks, marks like All Brand for brand cereal. These are words that have a clear connection with or are descriptive of the goods and services. And you can get protection for these, especially if you use them a lot, but it's harder, it's weaker, it's not as beneficial. So you really want to be careful at the start when you're choosing the trademarks that you're going to use, that you're getting yourself the best protection you can. That also brings us to Pitfall 7, open source, and the misuse of open source, which is something to be aware of as you move through any process and from the very beginning. A lot of people think that open source means no strings attached, but there's a variety of different open source licenses, and they all have different obligations and different requirements, and different sections of code can be covered under different licenses and different obligations. So there might be a requirement that you give an attribution statement, that you say who originally wrote code if you're bringing in some sort of open source code to your project. There might, in some cases, be a requirement that you not commercialize software that you build off that. And that could be extremely dangerous if you're bringing something in that you're not allowed to ask people for money for. That's pretty rare, but it might happen. Now, the GNU GPL license, which is very widely used, it doesn't require that code be free as in lunch, but it does require free as in freedom, which means that if you modify the code, you have to release it under the same terms, so someone else can modify it too. And that could be an issue for you if you want to make your own code open source, because if you spread it, if you make it available, you can ask people for money if you're using, say, a GPL license, but they could take that and then take the copy that they got from you and release it onto the internet completely free without any attribution possibly, or without requiring that other people pay you for it. So that might be really dangerous too. Basically, when you're using open source code, which can be super useful, you want to make sure that you know what you're bringing in and what you're relying on and what your obligations are, because you don't want to rely on something that turns out to not do what you want. Likewise, Dennis mentioned a bit about this, but we often see pitfall number 8, we see agreements between employees or partners or other people you're dealing with that just aren't clear about who's going to own any IP that comes out of the engagement. If there are joint works, if you're having a conversation and something develops, who will own that? Will you own it jointly? Will it be yours? Will it be the other party's? If the other party is not in Ontario or not in BC or not in the same place as you, whose law will control the agreement? Maybe it's California, maybe it's Poland. You should make sure that you know that, and if it is say in a language that you don't speak. If that's the original agreement, you should try to get someone who speaks the original language and is a lawyer in that country to review the original agreement to make sure that you know what you're signing up for. Also, with employee and contractor agreements, is it clear that your company will be the owner of the IP? There's a variety of rights associated with copyright, such as moral rights, that have to be explicitly waived, or the original coder keeps them. They don't transfer with normal copyright. So that has to be explicitly included, and that's often left out. Also, with unclear ownership, data licensing is becoming a significant new issue. Knowing where your data comes from and whether you actually have license to do with it what you're doing, if you're using it for training data, if it's a licensed data set that you've got from somewhere else, or what if you're building a training model by collecting the data that your users put into your system. Are your users aware of that? Have they agreed to that? Is it a reasonable use? So these are all things that you need to consider as you collect data or use data for training purposes, or even just basic analysis, depending on your use. And so that is also related to pitfall number 9, which is this use of standard, or just in some cases auto-generated terms and conditions or other agreements, because you can easily go online and download an NDA template or terms and conditions from the app builder that you're using, but those often don't cover the things you need them to cover. You might be overcommitting, like there might be discussions of payment policies, but you're just providing a demo site that isn't using Apple Pay, but now you have these terms and conditions that bring in requirements for Apple Pay. So why are you doing that? You also might be undercommitting. You could not have policies that you want to have, or not be clear on things. For instance, if you're using, if comments and forums are a large part of what you're doing, you probably want some kind of policy around content moderation that you can point to if it becomes an issue. But a lot of these standard agreements don't have terms like that. So it's always really a good idea to go through every terms and conditions and all these privacy policy agreements that you're agreeing to abide by, and make sure they make sense for you and not just for anyone on the internet. There's also, I mean, we all know that privacy policies and requirements for privacy are changing rapidly. So it's really important to keep an eye on that, because a lot of privacy policies that you get from these systems are fairly outdated, and it can be dangerous to not have policies in place that do what you need them to do. Similarly, and keeping with the theme of strategy, our last identified pitfall is not having a long-term plan. So you don't have ways of getting out of agreements or transferring agreements to other people. If in 5 years you have a really awesome acquisition opportunity, if you can't transfer an agreement that you sign now to someone else without requiring the other party's consent, that could be complicated for you, and it could get in your way. And so this is the sort of thing that you might not think about when you're setting up a company, but it's really worth dealing with even in the early stage, because down the road it could be a problem for you, and you want to make sure that you have all these war-gamed situations worked out so that nothing gets in the way of what you want to do later on. And that, I think, should bring us to, we have a few minutes left for questions, so if we have any, we'd be pleased to hear them. And
we don't have any questions in the chat box, but if anyone in the audience does have a question and they just want to unmute themselves, feel free to ask.
Yeah, a question here is if we're sort of having to look at prioritizing, you know, the three best things to position ourselves on an IP front, you know, sort of based on this, what would you sort of suggest would be those top ones?
I think, you know, probably if top three, I would definitely think about your brand strategy, right? Because you're going to be out in the marketplace. So I think considering your trademark strategy, at least having freedom to operate from a trademark point of view would be important. So don't start getting out in the marketplace with a brand that, you know, a larger competitor is going to find confusingly similar with one of their product lines. Like we come across that quite a bit, where, you know, did you consider that this big company has a sub brand that is similar to what you picked? I think the other thing is more on the hardcore kind of patent side of things, just understanding the landscape. You know, maybe you don't jump into patenting activity, but taking a look at what your competitors are doing in terms of patenting activity, like understand what's out there, what do those patents look like. So I think at the early stage, at least having a sense of what the landscape is, so that when you're talking to maybe investors or funders, or just, you know, just as you're developing your strategy, you're taking a look at what your competitors are doing and analyzing that and getting yourself educated, I would say, is another really important thing. And then finally, it's organization. I mean, the biggest issue I find is we work with companies in the digital space, and a lot of them are growing really fast and going through various, you know, due diligence over, you know, either, you know, you're going through due diligence because you're trying to get another round of funding, or you're going through some kind of government gatekeeping to get other purse of, maybe it's shred or something. Things are not documented, right? You don't have your agreements properly organized. You know, that ranges from customer agreements and vendor agreements to employment contractor agreements. You know, where is all this information being stored? Your trade secret policy, if you do have information that's staying internal, like how are you organizing all this information? And it sort of speaks to what Dennis was saying earlier about, you know, having kind of a building out sort of an IP culture is, you know, who are you going to develop some kind of committee internally that's going to be looking at these types of issues? But I think at the forefront, be organized. But really, it's that freedom to operate piece. If you're not taking active steps to protect yourself, make sure you're not taking active steps to step on anyone's toes, and then be organized. And I find a lot of times I get these late night phone calls from folks, or we all do, all of us get late night phone calls saying, oh my gosh, where's that agreement? I need to show them, you know, this particular agreement, or I need to show them this, that, or I need a report ASAP. And you can't as a company find those important documents. And when we talk about IP, we're not just talking about patents. Contracts are a very important form of intellectual property that needs to be managed. And as we saw with Amazon and Ecobee, can be used very strategically to keep people out of the marketplace.
I think one of the things to add there, though, is not getting ahead of yourself. Oftentimes we'll see startups that have a really interesting marketing plan, and they've gone ahead and developed their look and feel and things like that without doing any due diligence related to whether or not they potentially own the trademark that they've settled on, and also, you know, the thing about public disclosure, getting your head ahead of yourself by letting the genie out of the bottle a little bit too soon. So those are things, just getting ahead of yourself and not thinking about the IP as early stage as you should.
Mm-hmm.
If there aren't any more questions, I wanted to thank you, Natalie, Dennis, and Liz. I think a lot of what you said really would have resonated with this audience. Natalie, I love the fact that you pointed out how important it is to be careful when you're talking to companies before you start sharing too much information, and the kinds of horror stories that I know we've all heard about, and the horror stories that we hope that our members can avoid. Your comments, Dennis and Natalie, both about building an IP culture really, again, something that's so important, something that everybody can do because it really doesn't cost anything. It's really just turning your mind to it. And so many of the successful companies that we've seen, all of us have seen, really do have that culture, really do have that philosophy of it being important from the get-go, right? Just turning your mind to simple things like NDAs, where your contract's stored, what's the landscape look like? All those are pretty, I mean, yes, some of those things you need some help with, but those are things that can be done pretty easily and are important to do. Liz's comments, particularly in the context of collaborative arrangements that supercluster members have to participate in, around making sure that you have the rights around third-party IP before you start sharing it, thinking about the implications of open source. You might have thought about it for your own company, but when you start sharing that with third parties, what are the implications around that, right? So those are all very, very relevant points. So thank you very much. I think the practicality and the robustness of the discussion was really useful. I mean, we so often hear presentations that are high level and academic, but this was really down for the things that are important for these companies as they start engaging through these very important issues. So thank you for that.
Thank you. And